My name is Jocelyn Martel. I'm a professor of finance at the ESSEC Business School in France. My main area of research is corporate bankruptcy and corporate reorganization in bankruptcy and out-of-court restructuring. My main interest also is to look at the impact of different bankruptcy regimes on the allocation of resources in the economy. Now, there's a whole set of bankruptcy laws in the world, and I'm interested in studying how they function and how they impact on the incentives of firms and creditors in reorganization. One has to understand that there's a whole spectrum of bankruptcy laws in the world, going from pro-debtor to pro-creditor and hybrid system like in the US and Canada. In the context of this roundtable, my first point was to introduce a participant to the functioning of bankruptcy laws, especially the criteria that may be desirable from an optimal allocation of resources. The second point I was trying to make is to make the link between bankruptcy law and barriers to exit. Now, we know that depending how you define your bankruptcy law, this may have an impact on the entry and exit of firms in the economy, and having a better understanding on how these laws affect these elements is very important from a regulatory point of view. The last point I try to address is the link between bankruptcy law and antitrust laws. Now, we know that they both have common objectives in terms of the allocation of resources, but they may have conflicting goals. For example, bankruptcy law is backward-looking. It is interested mainly in maximizing the value of the firm, in finding a rapid resolution to financial distress, and they need a short calendar to be able to find a quick solution. On the other hand, antitrust laws is interested mainly in the impact of the sale of assets on competition. So it's forward-looking and interested on the impact of competition on future consumers. It takes a longer analysis and it has a longer calendar. Therefore, these two laws can contradict themselves, because on the one hand, you may need to find a rapid solution to financial distress, and on the other hand, you want to make sure that the allocation of resources will be such that there is no impact on competition. In that context, this means that regulatory bodies of both bankruptcy and antitrust need to work together to find the best optimal solution when a firm is in financial distress.